Well, thank you for staying with us on the AM show on Joy News, and hopefully you are enjoying your Easter Monday. But we're here to you with the big stories now as we get into some legal matters of great concern. Topical, especially because they are shaping our jurisprudence and our judicial processes in this country. And coming into sharp focus, the 1992 Constitution of the Republic of Ghana. Now, we know about all of what has transpired in recent days and weeks on the back of the Assin North Member of Parliament, James Gyakye Quayson. And yes, he still remains Member of Parliament. But per the 5-2 ruling at the Apex Court, he has been injuncted from acting or carrying himself as such, but he still remains that. The recent development we have is that he is seeking for the Court of Appeal to fight the dismissal of his case. In fact, he is fighting the dismissal of his case there. There's also talk of relistment, and there is also that outstanding issue still at the Apex Court when it has to do with the constitutionality of his election. There have been thoughts that have been shared by the likes of Professor Kweku Asari. We'll be getting to some of them, but one of those topical ones that he should simply resign to circumvent the entire process and then for a by-election to be held and for him to make himself a viable candidate for the NDC. Well, helping us discuss all of these issues, we'll be hearing from the NDC legal dons. But first, let's be joined by lawyer Bobby Banson. Bobby, a very good morning to you. Thank you for joining us on the AM show.
Good morning, and thank you for having me once again.
It's always good talking legal matters with you on the AM show. So tell me, what is your reading? I don't think I've had a discussion with you. What is your reading on the back of what happened recently in the Apex Court and the 5-2 ruling? Your initial take from there.
You know, one thing that people have spoken a lot in the context of, for lack of a better word, criticizing or bashing the judiciary is that when it comes to political cases, it's almost always unanimous. If it's not unanimous, you get to know, okay, this one was appointed by this government, so they voted in favor of them. When I was reading, I was hoping that I could see people speak, especially those that have been very loud, criticizing judiciary for voting on partisan lines, to say that, oh, okay, this one, two of the persons who were appointed by the ruling government voted against or ruled against the submission of the Attorney General. They have not said that. And for me, it's marks of some level of inconsistency in that analysis.
Let me play devil's advocate here. Let me throw a spanner in the works. This is on the back of people complaining time without number and even going ahead to call it, like I've seen in some posts, unanimous FC. Just playing on words, that it's always a unanimous decision. But then, isn't it crucial that on the back of what Albert Kandapa said, I mean, we're seeing some of these developments?
Again, that is why unfortunately, you see the judiciary, the judges do not have an opportunity to come and speak to these things in the public space. But look, if you read the dissenting opinion, the lawyers for the MP did not even put up a response in substance to the application for injunction. They raised the preliminary legal objection. And from my reading, unless I misread it, that was all that they did. Now, the two other Justice Amegache and Agnes Doji, I think, raised very, very important legal objections to the application in substance and even to the writ that had been filed in the Supreme Court itself. And these submissions that they made on their own had not been put forward to them by the lawyers for the MP. And so wherein lies the bias? People must take emotions out when they are speaking about judgments. Because judges, yes, they are human beings. They are bound to make mistakes. We cannot say that every decision from the High Court, Court of Appeal, and the Supreme Court is perfect. Some of us would agree with it. Some people will accept it. But when we are criticizing them, I believe we should be careful. And this is one case where I was hoping that part of the discussion in the media space, especially by the persons who have always criticized them, that, oh, this one was appointed by this one, that is why he voted. Look, the two of them gave very, very sound dissenting opinions, very, very sound. And these were not put forward to them by even the lawyers for the MP. And so we should give them that credit, that they do not just sit there to vote on partisan lines, or they do not just write things because they want to write them.
I've just forgotten.
And they put a lot of reason to their decision. We may not all agree with the conclusion, but that is the beauty of the law. I've
forgotten the name. The name of this justice just escapes me. But you recall, for example, there was an NPP administration that gave him the opportunity of being on the Supreme Court, and then the election petition, 2012, the first one, came up. The name just escapes me, and he was one of those who voted that things had been done the way they should have been done, and that the president then, former president John Dramani Mahama, should be retained. When his name comes to mind, I don't know why his name has escaped me, but when it comes to mind, I'll mention. So that feeds into what you are talking about. But the other angle that you've also broached or touched on has to do with the fact that they are, in fact, fallible, and that they make mistakes. There are so many landmark cases, not just in Ghana, in better established democracies across the world, where even landmark decisions have been overturned. So I feel also that isn't it justified when people question the system in this manner, even lawyers, because we are continuously fine-tuning our judicial process. Is there any error?
I have criticized some decisions of the Supreme Court in writing, published.
Yes, I think the justice's name is Bafuboni. I think it is Bafuboni.
Yes,
I think so.
I have published articles criticizing some of the decisions of the Supreme Court. Like you said, it's the beauty of the practice of the law, and so there are decisions in other jurisdictions, like you use the term, well-established legal systems that have subsequently been overturned over time. That is the law is a human. The Constitution has been described as a living organism. It grows. So over time, the circumstances will be different. But when we are criticizing the decisions, my only problem is when it is criticized as if the judges only vote on partisan lines or to suit those who... That is my worry. So you may disagree with their conclusions, but it is very unfair to say that somebody who has practiced law for 30, 40 years would lose his sense of reasoning only because he was appointed by, or he has to vote in line with those who appointed him. That is very harsh. And I think that those who continuously toe that line should use this, and then they should be careful on criticizing the judges on those lines. I'm not saying nobody should criticize them. I have said that they are human beings, they make mistakes. Academically, you have an opportunity to criticize them. But if you criticize them on the lines that they only vote because of the persons that appointed them. Here we go with an MP where two judges appointed by the ruling government disagreed with the submission of the Attorney General and even raised very potent legal issues that the lawyers for the MP did not raise.
Let's get into some of those potent arguments from the obiter, if I'm correct, or the dissenting views.
The dissenting opinions.
The dissenting opinions of these two justices. Which ones for you are things that we should reflect on? Because I'm also keeping in mind some of the things that other legal luminaries have said, like Professor Gyakye Quayson, talking about, citizenship and allegiance. And we'll get to that point. But when you read the dissenting opinions of these two justices of the Apex Court, you say that they make crucial points. What are some of the crucial points that maybe we ought to be looking at? Because again, we are in a continuous process of tweaking our 1992 Constitution, which has not seen change or much change since that period.
The decision delivered for me raises, like almost every decision, two important aspects of law that I think is worth discussing. One, the procedural gymnastics, for lack of a better word, and two, the substance of the case.
Okay.
As at the date of the decision, one thing that, and I don't know why, you said you'll speak to the NDC lawyers, maybe they would explain. As we speak today, the decision of the High Court is not even on appeal. I hear you say they are now going to file realignment, what have you. So as we speak, the NDC or the MP, let me not use the NDC, the MP did not pursue the appeal against the High Court decision. And it was struck out for want of meeting the conditions of appeal. which is like basic things like paying the bond for the appeal and signing the bond.
Right.
And I wonder why. Because if you are saying that the decision of the High Court is wrong, you have filed an appeal. And remember, with appeals with the members or challenging the election of a member of parliament, it ends at the Court of Appeal. The Supreme Court has nothing to do with it. And so if that is your final appellate court and you don't pursue it, what were you trying to achieve? Now, on the other hand...
So in this instance, just to clarify,
yes,
we're very clear that, and the other day when I had a discussion with Gary and some others, Roxanne in the studio, it was made clear that, in fact, on the back of the High Court issue, yes, there had not been an appeal. So that decision actually stood. And that is why, for the constitutionality of which we are in the Supreme Court as well, because that is the substantive case. Apart from the bit about the injunction being imposed, there is a constitutional issue about whether he was indeed elected constitutionally, which is yet to be ruled upon. But in this instance, we also know that the Member of Parliament is in the Court of Appeal to file a stay of execution of the court's decision to strike out his earlier appeal against the judgment delivered by the Cape Coast High Court. Are you aware of that?
I am not aware of that. If it is indeed a stay of execution, I wonder how procedurally it will. I have not seen the documents that they are relying on, so I would not want to speak to it, except to say that, you see, the dissenting opinion touched on very fundamental things. One, a High Court has delivered a judgment,
right,
declaring that at the time you filed your nomination for election, you were not qualified. I'm using the words loosely, okay, not quoting exactly what the High Court judge. You have not appealed against it. It was not the Member of Parliament who went to the Supreme Court. It was not. If it was the Member of Parliament who went to the Supreme Court to ask for constitutional interpretation of those articles, then one would have said, okay, he's trying to challenge it. But it was the plaintiff. So the dissenting opinion, or the judges who delivered the dissenting opinion, said, what are you coming to the Supreme Court to achieve? Because constitutional interpretation is not done in a vacuum. It is mostly done in the application of facts, or it is done in the context of facts that have been disputed. And so if your constitutional interpretation would result in a rehearing, again, I'm using the word loosely, may not be the legal terms used by lawyers, but I want to assume that most of your viewers are not lawyers, a rehearing of the High Court's decision, then you are sort of reinventing the wheel. And so for them, that is those who were in the dissenting, the minority, you cannot use this means of invoking the original jurisdiction of the Supreme Court to enforce a judgment of the High Court. When a High Court delivers a judgment, it can be enforced by the means known in the High Court. It can be enforced by contempt of court, which I think is the most suitable in this case, where the High Court has declared that you were not qualified, and so your election is a nullity, and you continue to hold yourself out. Those that have been affected by the decision, or the judgment creditors, may decide to have brought an application for contempt. Now you see the procedural difficulties that the plaintiff may have faced, that you have an MP who is, quote and unquote, evading services of court processes. That is why I believe in the Supreme Court he was even served by substitution. I think so. And so if you want to cite him for contempt, which is very difficult to serve by substitution, you have to serve personally, then it becomes a problem. That may be why the plaintiff decided to go to the Supreme Court to commence that process. And so there's a lot of procedural landmine in terms of the rules of court and how it's applied with this decision. And I want to think that over time, another bench in a similar matter, or perhaps in the final judgment that will be delivered on the substantive case, the Supreme Court may clarify some of the things they have said and the effect on practice of the law going forward. Whether or not someone who has obtained a High Court judgment, which on the date that the Supreme Court delivered its ruling on the injunction, was not the subject of appeal, can invoke the supervisory jurisdiction of the Supreme Court which will in effect be an enforcement of the High Court judgment. That may be a question that the Supreme Court may clarify as we go forward, because as it stands now, if you want to take it as the ratio, then it becomes a problem. Yeah.
Right. Just hold for me, Bobby, and let me bring in former Member of Parliament for Tamale Central, Inusaf Hussaini. Mr. Hussaini, it's a pleasure having you join the conversation this morning.
Good morning. How are you?
I'm very well. And happy Easter to you.
Oh, good, good. Happy Easter to you. Blessed Easter. Right.
Thank you. Let's get into the Assin North Member of Parliament's case. Now, we hear that he is at the appellate court, and it has to do with some releasement and also appealing. Are you with me, Inusaf Hussaini? It appears we've lost Inusaf Hussaini. I will get him right back on the line and, put the hard questions to him and also find out from the NDC's end what exactly the way forward could be, because we'll also be hearing from the likes of Baba Jamal. But let me quickly come to you, Bobby Banson. So the Supreme Court has explained that it's... Bobby, just hold for me. My apologies for this. Inusa, welcome back. Can you hear me?
I can hear you.
Right. So on the case of the Assin North Member of Parliament, and he still remains Member of Parliament, he's just been injuncted from carrying himself as such. We hear of this situation where he's at the appeals court fighting the dismissal of his case, and we also hear talk about releasement of his case. Some lawyers say they are unaware of the situation. What is the reality of that? Do you have any idea?
Thank you so very much, and once again, happy Easter. The matter of the Assin North MP was appealed against, the High Court decision was appealed against in the Court of Appeal.
Right.
While pending the Court of Appeal, the petitioner applied to the Supreme Court. Now, the back and forth of the Supreme Court and the fact that he had to be served, and then he was given some time to file his response to the petition, the motion for injunction. It made the pursuit of the High Court matter take backstage. And so while the rules of court required that he filed his appeal within a certain limited period of time, I think he was out of time. And so the appeal was struck out. But it's a normal procedure of court. I think that he is going to court to have it relisted. Because this matter has to be decided on its merit and not on technical grounds.
So does that mean that as we, speak now, technically, the High Court's decision still holds?
Well, there's an appeal which has been struck out. Okay. Now that is the confusion that is surrounding this case. Now, so the High Court gave a judgment in the matter. The judgment was appealed against. Before the appeal could be heard, the petitioner went to the Supreme Court. The Supreme Court exercised its jurisdiction to injunct the MP. Now you ask, and that is an interlocutory matter. The injunction is interim. That is between the commencement of the case and the final determination of the matter. And so, being an interlocutory judgment, I've heard people argue that the High Court decision is a final judgment. Then the question is, how can the Supreme Court exercise its jurisdiction to injunct a member of Parliament when there is a final judgment? Clearly, the only way you can reconcile it is that the appeal court took notice of the fact that the MP had in this case, the respondent had appealed against the decision, being the appellate respondent to the Court of Appeal. And so that was why they exercised that jurisdiction. Otherwise, it would lead us to a lot of confusion.
So as it stands now, again, it is left to the apex court to determine that final issue, the substantive issue of the constitutionality or otherwise of the member of Parliament.
There are two matters pending.
Right.
The first matter is that the judgment of the High Court that has not appealed the case. Now, what is the real and true intent of that provision that seeks to disqualify a person holding dual citizenship? from holding public office. Okay, now is it when he contests or when he filed? To what intents and purposes will that interpretation, an interpretation will put on that provision that will not lead to an absurdity? Okay, so initially the petitioner counsel argued that there was no issue of interpretation, but I've heard that subsequently he agreed that, or they agreed that there was an issue of interpretation. So the matter, the argument of the respondent, in this case, respondent applicant in the Supreme Court, is that the High Court ought to have escalated the constitutional interpretation to the Supreme Court for an interpretation, as that will have a bearing on the decision of the High Court.
Wow. So that makes for a very interesting picture. But just hold for me, Inusaf Hussaini. Let me also say a very good morning to Baba Jamal, who joins us on phone. Baba, a very good morning to you.
Good morning, my brother.
It's a pleasure having you join this all-important conversation. Just before I get to you, Baba Jamal, just hold for me. I wanted to acknowledge you. Let me, because I believe Inusaf Hussaini is on a bit of a time leash. So as it stands now, just to run this by you, the Apex Court, in delivering its decision, did say that it was hoping to uphold the Constitution, to protect the sovereign will of the people without subverting the Constitution. That is the rationale, basically, behind the ruling they delivered. What is your quick reaction to that?
Well, the jurisprudence of the Supreme Court has not left everybody confused.
How so?
Because the Supreme Court in situations like this always tries to hold the balance between representation and the requirements for justice. So, and there are numerous decisions of the court in which that balance has been upheld.
Right.
But it looks like in this particular case, and in recent decisions of the Supreme Court, a new jurisprudence is emerging, and that's a jurisprudence of convenience.
A jurisprudence of convenience?
Convenience.
How so?
Because, you see, when the Electoral Commission decided that they wouldn't use the birth certificate and the voter ID card, the old voter ID card, for the purposes of establishing the citizenship of a person to get onto the new register, the Supreme Court upheld it. They upheld it. But in this case, again, the Supreme Court decided to overlook the exercise of discretion of the Electoral Commission when the petitioner invokes their jurisdiction in the first instance to determine whether or not the MP, the embattled MP, was eligible to contest the election. The matter had come before the EC, and the EC, upon a review of all the documents submitted by the petitioner, qualified the petition. The respondent qualified the respondent to contest. In one way, you can see what is happening in court as a review, a judicial review of the administrative decision of the Electoral Commission. So you have, in one breath, the Supreme Court is holding the independence of the Electoral Commission to take decisions that it is mandated to take under the Constitution. In another vein, the Supreme Court is saying, no, that decision as an electoral body, you cannot constitute yourself, or we are reviewing your administrative decision to qualify somebody to contest, even though they have not said that in clear language. So it's clearly introducing some form of uncertainty and a matter of convenience in the jurisprudence of the Supreme Court.
Is that a problem? Is it dangerous for our democracy?
It's very dangerous. It's very dangerous for our democracy. It's very dangerous for the practice of law, because lawyers and people who go to seek the intervention of the court should have an idea which way the Supreme Court will go, which way the courts will go. That is the essence of precedent.
But should the courts be that predictable? I mean,
yes. Because you are going to advise your clients. If you come to me with a case, I'm going to review the law and the cases the Supreme Court or the courts have decided, and tell you that you stand 50% chance, 60% chance, something. In this particular case, there is no way the Supreme Court or the court will rule against you because this is the law. I should be able to tell my client that. And that is the basis upon which we go on appeal. That's the basis upon which we go for a review of the Supreme Court decision. In fact, ask yourself, the Supreme Court can depart from its own judgment. Why is that inserted in the Constitution? Why is that? That clearly tells you that the Supreme Court can be wrong.
Okay. Baba Jamal, I'll be with you shortly. Just hold for me. Just be patient for me for just about some 2 minutes. So, Inusa, looking at, you've been accused as well, so some members of your fraternity, of declaring the Supreme Court, for example, as being unanimous FC. They are always unanimously against you. That is what some of you have said. In this instance, we have a 5-2 decision coming from the Apex Court. How do you feel about that?
Was it intended to satisfy Kandapar?
Is that what you think it was? It was intended to satisfy Kandapar?
Because you say my fraternity, but I had Kandapar loud and clear. I had Festus Abuaji loud and clear. I've never known Kandapar or Festus Abuaji to hold party cards. So, and that comes immediately after Kandapar's warning. So, was it intended? To all intents and purposes, it was a 5-2 decision.
And so your reading of the case, finally, to wrap with you, Inusa. So moving forward, what are your expectations of what is pending before the Apex Court?
Well, my expectations are that the matter is so confusing that the first approach is to go release the case, because people are running wild with a final judgment when in fact there's no final judgment. In fact, when the Attorney General, after leaving the court, said that the respondent because in the Supreme Court should go back to the Court of Appeal and have his case done so that they can expedite action on it. Now, so it is important that the respondent pursues his appeal at the Court of Appeal, while also pursuing at the same time his invocation of the exclusive jurisdiction of the Supreme Court to interpret the provisions of the Constitution that deal with dual citizenship.
Inusa Hussaini, thank you so much for joining us this morning on this conversation. We're very grateful.
Thank you.
A legal brain in the NDC and, of course, former Member of Parliament for Tamale Central. Bobby Banson, do hold for me because there's a lot that I'd like to talk to you about. But Baba Jamal, is Baba still with us?
Yes, I am with you.
Great. You've been hearing what Inusa Hussaini has been sharing. I just want some clarity, further clarity if possible, because you are on the case. What exactly is being pursued in the appellate court, the Court of Appeal, and what exactly is being pursued at the Apex Court, the Supreme Court? Just break it down for non-lawyers, you know, the bite-sized bits.
Okay, let me say that I completely agree with my senior Inusa Hussaini. And I think his line is going off and it's making a lot of noise in my phone. So maybe if you can check his line.
Right. We're dealing with that. Is it better now?
I absolutely agree with my senior and colleague Inusa Hussaini when the expose he has given on the decision of the Supreme Court. In fact, that decision has left many lawyers confused as to what is the law now, because like he said, there must always be clarity on decisions and there should be some level of predictability to know how cases go. And the Supreme Court is the apex court that always gives direction when it comes to issues like this. But before I even come to the Supreme Court decision, you have asked a question, and I want to deal with that. You see, after the decision in the High Court, Cape Coast, it was at the High Court that when the issue of Article 94(2)A came up, we requested that particular provision has never been interpreted by the Supreme Court. And so we think that issue lends itself or seeks interpretation, and we made an application for that. At that level, Mr. Nimfa, who is the plaintiff in that case, through his lawyer, Frank Davis and co, opposed our position that that particular position does not need any interpretation. But we insisted that it is only the Article 94(1)(a), which was interpreted by the Supreme Court in the Zenato case. But in 2(a) has never been interpreted. So when this decision, when the High Court decided to, overrule us and continue to give the judgment based on the same article, we decided to go. We went to the appeals court, and you see, there are still people who still think that that decision has not been appealed. Yes, we appealed it, and the appeals court, strike it out for non-compliance of some directives. But on the 29th of March, we have filed an application to relist the case, the appeal. So as we talk to you now, what is before the appeals court is to relist the same appeal, which we have done, which we have filed. And also filed...
And that is before the apex court?
No, that is before the appeals court.
The appeals court, right.
And we have also filed for a stay to ensure that our relistment is heard, application is heard, and then we can go on with it. So that is before the appeals court. So when you go to the appeals court now, we have our application for relistment before the appeals court. Now, when we went to the appeals court before the case was struck out, we still canvassed an additional point, standard that the appeals court should allow for the interpretation as required by Article 132 under the Constitution. But that also was opposed by the plaintiff through his lawyer. So it is surprising to note that the same people who opposed our request or application for interpretation of Article 94(2)(a) from the High Court to the appeals court now goes behind us to file a fresh writ to request for interpretation of the same article that they opposed. So what is before the appeals, the apex court now, or the Supreme Court now, is a writ seeking the interpretation of Article 94(2)(a), something they opposed at both the High Court and the appeals court level.
Right.
So if you ask me what is before the apex court, that is, and you see, when they filed the writ, then they went ahead to apply for an injunction against Mr. Gyakye Quayson. And this is where the confusion is. How can you go for interpretation for an article in the Constitution? Now, the decision that you are trying to enforce, that judgment is based on Article 94(2)(a), largely based on Article 94(2)(a), which you are now seeking interpretation. So how can then the Supreme Court can go ahead and injunct the MP when they have not even interpreted the 94(2)(a)?
Right, so we're fully aware that you are not in agreement with the apex court as far as that is concerned.
No, but we have said that we are vehemently disagreed with them.
Let's talk about the relistment in the right. Let's talk about the relistment in the appeals court. You have spoken about serious errors of the law in the decision of the court, and that, quote, if a stay is not granted in respect of that decision, it would amount to the Court of Appeal being allowed to infringe on the rules of the court under which it is required to operate, as well as to ignore binding decisions of the Supreme Court and fundamental rules of natural justice with impunity. It goes on and on. But you've also been talking about a multiplicity of suits, which, if we don't get right from the flow of events from the Cape Coast High Court to the Court of Appeal to the Apex Court, we could have a multiplicity of suits. I want you to digest for me what exactly you mean by that. Why could we have this? And mind you, in all this period, it would mean that the people of Assin North would be lacking representation. Would that be in your interest?
So that's the confusion the Supreme Court has put.
Bobby, I hear you want to come in. Just let Baba Jamal answer, and I'll come to you for your quick take on that.
No, I actually want to ask him a question so that I understand his context of his submission, because I have not seen.
So on the back of what I just said.
Yes.
All right,
yes,
go ahead.
yes.
All right, so Baba Jamal, hold for me. Bobby, go ahead.
Good morning and happy Easter. Baba, I just want you to clarify some things for me, and because I have not seen the processes that you filed. First, before the High Court delivered its final judgment, you raised the issue of constitutional interpretation, right?
Exactly, in Cape Coast.
And asked the High Court to stay proceedings so that the High Court refers that matter to the Supreme Court for interpretation, right?
In line with Article 132 of the Constitution.
Yes. But the High Court refused that application from you, right?
Exactly. And
did you appeal against that decision of the High Court?
Exactly. At the appeals court, we did that.
Okay. Is that the appeal that was struck out?
Yes, that was the appeal. That was the appeal that was struck out for lack of compliance.
Okay, for non-compliance. Okay.
For non-compliance.
Now the final decision of the High Court. Have you filed an appeal against that one too?
And yes, we filed an appeal against the decision and an additional grounds of appeal for the interpretation of Article 90 of the decision of the appeals court not to allow for interpretation or refer the case to the Supreme Court for interpretation. Yes.
Okay. Now, that second appeal against the substantive judgment, that one has not been struck out.
No. You see, it was an additional grounds of appeal. So the whole thing was struck out for non-compliance. And the first appeal against the decision not to stay proceedings, or the second appeal, the substantive. What I'm saying is that it was canvassed as an additional grounds of appeal.
The decision of the High Court not to stay proceedings.
Essentially, it is one appeal before the court.
And that appeal is so that appeal before the Court of Appeal is the appeal first against the grounds of appeal, and I'm just summarizing it. The grounds of appeal is that the High Court judge erred when it arrived in that conclusion. And then two, the High Court judge also erred when it refused to stay the proceedings and refer the matter to the Supreme Court.
Exactly.
Okay, I understand now. Okay, you may carry on. Sorry for those questions if it's derailed your life.
No, it is fine. It has given us further clarity because I was also a bit befuddled when it comes to the bit about the transition with the High Court, staying its own bit. But you can go ahead.
So he has helped us to clear the thing that at the appeals court we filed an appeal against the judgment and then canvassed an additional grounds for the referral for the High Court's refusal to refer Article 9428 to the Supreme Court for interpretation in line with Article 132 of the Constitution. You understand? So now, what is before, and that is what was struck out for non-compliance. Now, we have, on 29th of March, we have applied for relisting that appeal. Now, the plaintiff now goes to the Supreme Court and requests that the Supreme Court interpret Article 94(2)(e), which they have opposed from High Court through the appeals court. Yes, and that is where the confusion is. I'm saying that. So they are asking for the interpretation of 94(e). And the decision of the High Court in Cape Coast largely is based on Article 94(2)(e). So if today the Supreme Court decides to interpret the Article 94 and it goes in favor of the respondent, what becomes of the decision at the Cape Coast court? You understand? If they today they interpret and said that the position of the High Court in Cape Coast was wrong, what becomes of that judgment? And if that judgment collapses, it means that the Supreme Court would have denied the people of Assin North the opportunity to for representation.
All right, Baba Jamal, yes. just to interject here. Some people from your own fraternity have said that it is not likely that there will be a departure by the Supreme Court on the back of what has been seen so far, even in granting the injunction. And so that is not a likelihood. The injunction that you even seek a review of by 5-2.
It gives the impression of the case being predetermined before even it being considered. Do you understand?
Right.
Because it gives it the impression that the case has already been predetermined. Because if the interpretation will have a bearing on the decision of Cape Coast Court, then why do you go ahead to injunct the person when you have not even gone into the merits of the interpretation that you are being requested, you have been invited?
Right. But is that something you agree with, that you feel by granting the injunction, basically the court is leaning in a certain direction, which will not favor your party?
That's the impression that is being created. Because you see, let me even draw your attention to something.
Very briefly on that.
As Minister Futeni said, there was a general conduct of the court to preserve the sanctity of representation in Parliament. And that's why, starting from 1996 in the Adote case, when Adote was given the opportunity, was challenged by Amon, she stayed throughout the court. When we came to Amewu, even Amewu, whose election was voted for by half of the constitution of the constituency, half of it, the constituency have voted for him. The court, when the court granted an application to stop him from being gazetted, the apex court said no, there needs representation in there, so he quashed that. Now, when you go to Techima, when the NDC candidate applied for an injunction against a disputed election, the court said no, allow the representation once we determine the case. There are about 6 more cases or 8 more cases in various high courts across the country. We have Domoro, we have Pusiga, we have Banda, we have Tamawe, we have Tefiwio, and we have all these things going on. None of them no court has entertained an injunction against a candidate because his election is being challenged. What we need to know, and please let me land on this, that you see, no matter how defective a representation is, a bad plan is better than no plan. The people deserve to be in Parliament. Somebody deserves to be in Parliament. So the decision by the apex court has rather departed from the general drift of the court's conduct. And this is not good for this country. That's why everybody is asking that. If you are going to interpret 94(2)A, and that may have a bearing on the decision of Cape Coast, why then step ahead to injunct him? Why not rather go ahead to give the interpretation so that we know the position? But what you have done now has kind of confused everybody, and in fact, it has now given the impression that even the case has been predetermined before it is a decision.
Baba, there will be more time to discourse on these as the Supreme Court, gives its decisions or rulings on the substantive issues.
The decision that is going to give, it has already said that it's Senadai. So until they take a decision on it, there will be no representation for Assin North in Parliament. Do you think that will be fair?
That point has been made, Baba Jamal. We're grateful. We're so grateful that you took the time to join us. Bobby, let me just wrap with you very quickly on these 2 points. So Professor Gyakye Quayson has said 2 things. I just want you to, in the next few minutes, react to them. One, he has said that to resolve this entire muddling issue, the member of Parliament for Assin North should resign, and then for a by-election to be held following the legal processes, and then put himself up for election again. Professor Gyakye has also said, and I just want you to react to this, that we are stuck in the 18th century if we are thinking that citizenship can be equated to allegiance. In other words, when he talks about Article 94(2), he says that while it states a person shall not be qualified to be a member of parliament if he owes allegiance to a country other than Ghana, it does not provide that a person shall not be qualified to be a member of parliament if he is a citizen of a country other than Ghana. Do you get the point? Your quick reactions.
With his first suggestion, I think it's maybe the best route for the MP. What it means is that once he resigns, the writ before the Supreme Court becomes moot, as there will be nothing to
exactly
upon. Yes, and then he can go through that process. As to the second leg of his submission, I think that when we take that approach, and that is why we have the Supreme Court to interpret it, it becomes an issue of so much speculation, because then if we as a country, we do not develop one standard that we will equate to allegiance, and we want to leave it on case-by-case basis, you would have people who have coming from different countries would have different levels of citizenship, saying that, okay, where I'm coming from, with this level, it is not allegiance. I think that it leaves a lot of room for speculation and for subjective analysis. And so if the country, by the Supreme Court, decides on one standard to determine allegiance or citizenship, I believe that we should go by it. So it's a case that I still would want the Supreme Court to come up with a final decision on. I was hoping that there will be a little more time, because and Ben, I shudder to say this. I see a problem with a lot of the procedures that have been adopted prior to the matter going to the Supreme Court. And I don't want to prejudice the outcome of these processes that have been filed. But it seems problematic from the explanation given by Baba.
So problematic that the NDC is not following the right processes? Is that what you're saying?
What I am saying...
The NDC's legal team. I mean, maybe there are flaws in the way they are addressing the issue, which may lead to their losing again at the Supreme Court?
No, I'm not talking about the Supreme Court. I'm talking about the processes that they have gone through. See, and again, this is my infantile experience and my reasoning, okay? You raised an objection to the High Court, or you applied to the High Court to stay proceedings and refer these constitutional provisions to the Supreme Court for interpretation. That was the most important, or that was the watershed of the whole case. My question is, why didn't the NDC pursue that one, like, to its logical conclusion? Appeal, follow the appeal, because if they had done that, you would have deprived the petitioner in the substantive case what he is doing now. And would have stayed proceedings in the High Court in Cape Coast until the Supreme Court determined this matter. Then you would have had the upper hand, or you would have been on the offensive in this whole case. And so that you would have, the High Court could not have delivered judgment unless the Supreme Court had interpreted that constitutional provision.
Right, but they missed that window. They let it go.
I think they let it go. And I think that it may be too late in the day to add it as an additional ground of appeal, because the time for filing appeals against decisions are time-bound. And so if you're out of time, then it's problematic. But I would want to, again, without prejudice, I have not seen the processes they had filed. But that is why I was asking Baba those questions.
Right.
Because then if you say that as it stands, I thought there were two appeals. But I believe you heard him say that, okay, there's only one appeal.
Right.
The appeal against the substantive decision of the High Court. And then they have now filed an additional ground of appeal, raising the issue of stay of proceedings for the High Court to refer the matter to the Supreme Court. That ground of appeal, with all respect, I think, from what I am hearing, is moot, because the matter is already before the Supreme Court. So what are you asking the Court of Appeal to do? And that may be how I think the lawyers for the petitioner then, did like we say in loose balance, did a double over them by, going to the Supreme Court on their blind side and then bringing the injunction. I have my own problems with the ruling on the injunction. I have my own problems with it. But so if we look at the procedures that had been adopted by the lawyers for the MP, they should have seen this coming, I think.
Okay. Well, we'll have to stay proceedings in the court of the AM show for now on this Assin North issue. Bobby Banson, always grateful to have you join the conversation. Thank you so much.
Thank you for having me, man.
Right. Do stay with us. We're taking a bit of a breather, and when we return, it's all about, well, the COVID-19 protocols have been relaxed, but there are calls on Ghanaians to still exercise caution, especially during these festivities. And interestingly, we have Easter and Ramadan coming together around the same time. How do we deal with the situations? How do we stay safe? Michael Owusu of the KCCR will be joining us as we share thoughts on these matters. We'll be right back on that discussion.